Hello again, everyone, and welcome to my channel where I show you how to navigate a Jewish divorce and avoid the costly mistakes that others have made. In today's segment, I will be discussing a recent divorce saga involving Ari and Avi Satz, where Ari has been a victim of a public humiliation campaign organized by Aura with the blessing of Avi Kahan from the New City Bezen. I will endeavor to show you that this bezen's decision was a total sham, but at the same time, it should not come as a surprise, since many of you who are veterans of this channel have watched my video series titled Rabbi Gestentner Refutes the Lies, which you can find in the playlist of this channel. In those series of videos, Rabbi Gestentner picks apart the lies and distortions and the reformations of halocho spewed by Avi Kahan and the other guests present at the co-live meeting. I will be leaning to return to the co-live series after this video to expose more distortions of halacha stated by Avi Kahan and Yosef Feigelstock. But getting back to the Ari and Avi Satz case, I have spoken to reliable sources who informed me that the background of this case involves the secular courts compelling Ari to enter into an agreement with Avi, where one of the provisions of this agreement was that he would agree to go to Beis Din. He was threatened that serious legal implications might occur, including facing jail time if he did not comply. I'm not at liberty to discuss what the serious legal implications is, but it is evident that Ari did not enter this agreement out of the noble goodness of his heart. Although Ari and Avi attended one session at the Beis Din of Avi Kahan in November 2021, Ari did not attend any more Beis Din's hearings, citing his distrust of Avi Kahan's Beis Din. Again, this is based on information that I received from a reliable source. My regular viewers are aware that I, like a broken record, repeatedly warn my viewers not to go to Beis Din in matters of divorce because of 4 primary reasons. Number 1, the laws of gittin are very complex. There are 90 dafim in Masechet Gittin discussing complex scenarios, and many Bati Din are ignorant of these halachas, and many more rule against the normative halacha, causing great sins to be committed. Number 2, the sages explicitly stated in Masechet Kedushin 6a and 13a, Kol she'en yodea b'tiv gittin v'kedushin lo yilo esek imohen. Translation means that whoever is not an expert in matters of Jewish marriage and divorce should not be involved in these matters. I don't believe that you will find anywhere else in the Gemara such admonishment of a novice in other areas of halacha as you do in matters of divorce. That should indicate to you that these halachas are quite complex. Number 3, the reasons the sages admonish these unscrupulous rabbis is because not only a mistake in matters of get will cause a serious sin of Eishes Ish, also known as adultery, but Chazal also terms such a mistake as me'uvas lo yochel liskon, loosely translated, that which is deformed cannot be repaired. A child born after delivery of a faulty get produces a mamzer which cannot marry a regular Jew. This defect is an everlasting spiritual defect, which will always stigmatize this mamzer or mamzeres. And reason number 4 is that anyone could just open up a Beis Din, and we don't have a system of checks and balances or a real Sanhedrin that can overrule a rogue Beis Din's decisions. In fact, let's listen in to Avi Kahan himself admitting to this when asked about corrupted Beis Din.
I don't want to answer, which is probably the right question to be asking. Is there such a thing as a corrupt Beis Din? I know of a situation in Florida. There's a girl who is waiting for her get, and the man who is not giving her get requests her to come to a Beis Din that they do not trust. Is there such a thing as a corrupt Beis Din? Yes or no?
Yes. Yes. We live in Gullus where every person, including myself, could decide that they want to open up a Beis Din.
Be it as it may, I will endeavor to point out to you the multitude of problems with Avi Kahan's ruling, which I will link for you below, that should bring awareness and clarity to why I say stay away from Beis Dins in matters of divorce. These Bais Dins are house of ill repute, which are one of several tools used today to strip a man of his halachic rights, civil rights, and fatherly rights. I will also be linking for you below an actual court report or transcript that recorded all the conversations during this bezen session that took place on November 2021. So let us begin. Number 1, let's take a look at Avi's Bais Din makeup. The bezen session began with just one rabbinic judge, Avi Kahan. But after questioning this peculiar one-man Bais Din, Avi introduces 2 more people to preside as rabbinic judges. Yes, a proper Bais Din should have 3 knowledgeable judges, experts in matters of divorce, to decide serious matters with serious implications. Let me remind you of the Gemara in Kedushin quoted earlier, that he who is not thoroughly knowledgeable should not be a rabbinic judge presiding in divorce matters. So who does Avi bring in to complete the 3-judge panel? Rabbi David Bartfeld and a licensed social worker, Mr. Isaacs. A licensed social worker? Is this what you call a Bais Din? So what is Avi's explanation to this aberration? The answer, as can be seen in the court transcript linked below, we use a social worker to augment the Bais Din as a mental health component. This appears very suspicious to me. Why a Bais Din belonging to Avi Kahan not only does not conform to a normal Bais Din composition that contains 3 rabbinic judges, but substitutes a rabbinic judge for a mental health professional. Could this be because he uses this mental health professional as a tool to force an illegal get by having the social worker brandish Ari or any other husband as having mental health issues, thereby justifying a coerced get against halacha? This tactic seems eerily similar to the civil courts that order forensic examinations of the litigants and almost always rule that the father is not fit to have custody without the father being allowed to have an independent and unbiased examiner. Let me remind you that the Torah laws do not follow the same procedures as secular laws and has stricter parameters set for its unique judicial procedures, equity, and due process. This mental health component is not only a break from the normative appearance of a Bais Din, but raises in my eyes great suspicion of his motive. This reminds me of a personal and unusual experience I had at a dentist office. I was being fitted for a crown and had to return several weeks later to have it cemented to my lower jaw. So I'm laying on the reclining chair, and lo and behold, the receptionist at the front desk was the one given the task to cement the crown to my lower jaw. My viewers, now be honest, how many of you would have just gotten up and ran out of that office? Where is the dentist? Why is the front desk receptionist performing a dental procedure? Well, I didn't panic, but went along with it. But that experience left me with a poor taste in my mouth, no pun intended, and never returned again to that office. 2 things happened here. Number 1, a total aberration from normal dental procedures. And number 2, there was no communication between the dentist and I, letting me know that the receptionist will be the quasi-dentist for this procedure. Returning now to our subject, Avi Kahan and his bezen procedures. Avi Kahan has stated in a YouTube Zev Brenner interview linked below that he's all about transparency of his bezen and its procedures, and I therefore ask Avi Kahan to please leave me a comment so I can share with my viewers as to why you substitute a 3rd dine for a mental health specialist, and why not a doctor, lawyer, accountant, etc. Why a mental health specialist? Could you, Avi, please also leave me a comment as to how many women in your divorce cases have been implicated as having a mental issue? In how many cases that you arbitrated, you ruled that the woman is not entitled to a get until she rights what she has wronged? Additionally, since you're about transparency, can you also leave a comment so I can share with my viewers why, as of this summer, you are no longer the pulpit rabbi of the Shul Congregation Kahal New City, New York? Have you been dismissed from your job? Are you relocating? Did you resign? Or is this a false rumor? Also, in the Zev Brenner interview, you seem to boast that your bezen procedures are fair, since you allow an appeal to be done at one of your pre-approved appeal judges in the state of Israel, namely Tzvi Gertner or Mendel Shafran. I'm sorry to inform you that this does not conform to halachic standards. I have a right to appeal any halachic ruling on my own, citing chapter and verse. This is not secular court. This is the court of Torah law, where every person should be able to put their feelings aside and care about arriving at the true halacha, which is what Hashem wants from Jewish judges. By you taking away my right, if I were a scholar, of presenting my own sided halachic arguments, or even referring your decision to an independent body of scholars of my choosing in the USA, you are essentially closing the doors of fair judgment and raises serious questions about your judicial honesty and fairness. In the court-reported transcript below, Avi Kahan appears uncomfortable at the appearance of Rabbi Klein, who's supposedly acting as Ari's Tohen or rabbinic advisor. I understand that in the rules and procedures of Avi's Bais Din, it doesn't allow for Tohanim, but then why do you allow attorneys and not Tohanim? Shouldn't all the litigants be afforded counsel that understands Talmudic law and makes good arguments in the defense of their clients? Once again, this raises suspicions that when Avi Kahan built his rules and procedures, they were constructed to make it harder for an unlearned and ignorant in halacha defendant or plaintiff to argue their case. But the real defining factors that make Avi Kahan's bezen ruling flawed at its core are the following observation. I stated earlier that halachic principles do not conform necessarily to civil procedures, codes, or laws. For example, if a man, let's call him Shmuel, were to proclaim in front of witnesses that he wants to give a get to his wife or commit to going to a Bais Din, and then changes his mind, he's allowed to do this according to halacha. The tractate of gittin is full of such examples. The mere pronouncing of intention of giving a get and then retracting his intention is 100% compliant with halacha. In fact, the Gemara even cites examples of a man that changed his mind because his wife did something to upset him, which is very common and very real, like we see here with the Ari and Avi Satz case. Yet, in the bezen hearing of November 2021, the transcript clearly indicates that Ari's Tohen, Rabbi Klein, made Avi Kahan aware approximately 24 times that Ari was being coerced by the civil court to appear at his bezen. He does not wish to have his case heard at his bezen, nor is he prepared to give a get at this junction. Yet in the YouTube video linked below, at approximately the 22-minute mark, Avi insists that Ari has voluntarily come to his bezen and voluntarily signed the arbitration agreement. This is a patent lie, as the court transcript clearly shows the multiple statements made by Rabbi Klein to Avi Kahan about the coercion, about him not wanting to be at his bezen, and that he was not prepared to give a get. Let's listen in to the dishonest statement made by Avi Kahan.
Don't know what it is. So let's define that.
So a sirif happens in generally one or two, 3 cases.
Let him respond. Go ahead, Rabbi Kahan.
A sirif happens generally one of 2, 3 cases. And this specific case we'll refer to is somebody who voluntarily, don't ask me why, but voluntarily decides to sign by a specific Bais Din, and then decides not to listen to the Bais Din at all, and not to show up to the Bais Din, or to show up and play a lot of shtick. And sometimes it's not the person's fault. He's guided in a very, very wrong way, which we could feel bad. And sometimes the person decides to threaten all the dayanim and get into his head that there were forged signatures, but at the end of the day, you have to listen to Beis Din, and if Beis Din paskin something, you have to follow through with it, and it's very sad when people don't. And when people threaten dayanim and they threaten their lives, which your caller has done, he's specifically called, not me, but he's called on one of the therapists who sat in on the entire because we felt we were dealing with mental.
So why do you, Avi Kahan, not state the truth that Ari changed his mind? Now let's contrast that for a moment. Let's contrast Avi Kahan's verdict with another case which is very similar to the Satz case, where a Mr. Gill from Florida had the same situation, civil court coercing him to enter in an agreement that stipulates that he must give a get. And Mr. Gill then proceeded to go to the Beis Din of South Florida and inform them that he was being coerced to issue a get. Yet the South Florida Beis Din verdict was diametrically the opposite of Avi Kahan's psak, and here was their response. I will also link this letter for you below in case you want to download it. As you can see, this letter for you below, the South Florida Beis Din wanted to do nothing with the get since coercion was involved. It appears that Avi Kahan invites coercion, and after repeated statements made by Rabbi Klein that Ari is being coerced, Ari does not want to be here, Ari does not want to give a get, Avi Kahan unleashes a brutal verdict against Ari, which included 1, placing Ari in a category of you can force a get, 2, giving Chavi permission to pursue legal action in the civil court, and 3, $150 a day penalty for every day that he delays a get. Do you understand now why I call these houses of ill repute Bais Dins? It should also be apparent to all that Avi Kahan's verdict is fundamentally flawed at its core because of his misrepresentation of the true facts of the case. The court reporter transcript does not lie. It's a recording of every statement made at that hearing on November 2021. But you, Avi Kahan, failed to tell your YouTube viewers watching the Zev Brenner show all the facts as stated in the court transcript and laid out by Rabbi Klein at least 24 times about Ari being coerced against his will and not wanting to be at your Beis Din. It should also be noted that the modus operandi of many corrupt Beis Dins is to print, or better yet, apply cut and paste halacha, and to write lengthy rulings to confuse the average unlearned reader of halacha, weaving in some authentic halacha with a lot of reformed, distorted, and manipulated halacha to allow him to arrive at his desired verdict without anyone noticing the inherent deception, as we see with Kahan's final verdict, a masterpiece of deceptive halacha. But you should also know that most corrupt Beis Din rulings don't have any merit to the rulings, since most of the cases cannot begin to get off the ground to even allow for a ruling to be made against a man, because of a fundamental and major violation of halacha committed by the wife, which the corrupt Beis Din has chosen to ignore, and applicable in the Ari and Avi Satz divorce case. With this, I mean the serious sin of litigating in civil courts. You see, Avi Kahan, in his fake piety, writes about the prohibition of using the secular courts in his verdict, but then issues Chavi permission to utilize these courts after rendering Ari Satz as a Masar of Ladin. With this permission, he is implying that prior to his verdict, it was prohibited for Chavi, his wife, to use the civil courts. Well, Chavi appears to have already used the civil courts from the start, as most women do, as I will attach below court papers indicating that she is the plaintiff and Ari is the defendant. Therefore, with such a fundamental violation of halacha, it would be forbidden to have assisted Chavi in any matter at a bezen sitting until she makes restitution. The Ramah explicitly states that anyone violating the grave sin of using the secular courts should not be assisted in any way, and even for a get. Therefore, Avi Kahan has violated the core principle of halacha, which states that it is forbidden to assist the Torah violator, and those that do assist are considered sinners of the same degree. Another point to his flawed verdict is the fact that Avi Kahan, in his halachic decision, makes references to previous rulings made by members of the Israeli Rabbinate. Well, in my last video titled Israeli Gittin Forces, I already proved without a shadow of a doubt, through the verbal testimony of one of its rabbis, namely Rabbi Lassery from the Petach Tikva Rabbanut, who stated that the Israeli Rabbinate's rulings are not in conformance with strict halacha, but base their rulings on Israeli secular law. This fact, coupled with a letter signed by many respectable rabbis attesting to the Israeli Rabbinate's shoddy and corrupt divorce rulings, should indicate to you that any rabbi who identifies with the Israeli Rabbinate and its policies shares their same reputation and bears the same halachic consequences to their verdicts as the Israeli Rabbinate. Therefore, any rabbi who supports or aligns himself with an organization or entity that is known to be corrupted, he himself is corrupted, and none of his rulings should be adhered to, as they emanate from corrupted and not halachic practices. In Pirkei Avos, chapter 1, Mishnah 11, Avtalion, the sage, says, "Scholars, be cautious with your words, for you may incur the penalty of exile and be banished to a place of evil waters," which refers to heresy. The disciples who follow you there might drink from the same evil waters. Avi Kahan is known to have been a disciple and influenced by the Israeli Rabbinate, and that is where he received his training. In fact, how ironic is it that in Avi Kahan's Bais Din webpage, which I will link below, he admits to being trained at the very same Rabbanut, Petach Tikva, where Binyamin Lasri has admitted in a voice recording that they do not rule by strict halacha, but instead rule by secular law standards. This appears to dovetail with the Mishnah and Avos just quoted above about drinking the waters of heresy. He apparently has drunk those waters and now comes to the USA trying to disseminate the heresy that he picked up from Israel. And last but not least, Chazal state, Mipnei aginuso akilu barabanan. In certain cases, and I emphasize only certain cases, we apply leniencies to help solve authentic aguna cases. However, the key word here is authentic agunis. The reason why Kahan's verdict is null and void is because most women today, including Avi Satz, do not meet the halachic standards of an aguna, because a woman who violates the Torah by immediately litigating in the civil courts, or a woman who has it in her power to negotiate a fair settlement but chooses not to do so, is not the aguna that our Talmud refers to, and therefore it is blatantly prohibited for anyone to break fundamental halacha principles of Jewish divorce and issue rulings of coercion of a get. Our sages would rule leniently only with authentic agunis, but once again, our corrupted rabbis have mislabeled rebellious women as agunis to justify their reformed halacha. In upcoming videos, I will prove from the Gemara and Rambam that the concept of aguna, as depicted by the feminist aguna organizations such as Ora and corrupted bezens, has been greatly exaggerated, mislabeled, and weaponized for the sake of harboring sympathy for people who don't deserve the sympathy. And now, coming full circle, we can also understand why Avi Kahan does not allow you to appeal his decision locally, but only in Israel, because in Israel, they have been so accustomed to forcing almost every get against halacha, and will therefore always agree with Avi's rulings of a coerced get. he can't find such universal support of his coerced gittin in the United States, and therefore does not allow you the right of appeal at another USA bezen of your choice. I would also like to make you aware that Avi Kahan has stated that he's affiliated with Concord Mediation and the Derech Shalom Center. One is a mediation group, and the other is a center that helps deal with mental health and other family-related matters. Although I support mediation and other non-court remedies, I strongly suggest that if you are considering their services, to please inquire if they are willing to give you in writing that none of their findings or opinions can be used at either a Bais Din or civil court setting. Additionally, you also need in writing that if mediation or Derech Shalom services fail to achieve their results, that you are not obligated to arbitrate your case at Avi Kahan or any other bezen. If they won't put it in writing, then that should be a red flag and go away. Do not go there. I've been warning my viewers all along not to go to any bezen in divorce matters, as you have just seen with the result in the Ari Satz case. I would also warn my viewers not to visit the state of Israel because of a new trap the evil rabbis invented. They advise the woman who wants to divorce to not file anything in Bais Din or court, as to not alert the husband of her hidden scheme, which is that they will travel as a family to Israel on vacation, and once there, contact the Israeli Rabbinate, who will have no problem coercing a get from her husband. But in today's video segment, which discusses the Ari Satz and Jacob Gill divorce, it appears that perhaps yet another new scheme has been concocted to trap men into going to bezen or issuing a get. In these two cases, we witnessed that somehow the courts compelled the litigants to enter into a voluntary agreement that contained a provision of either attending to a bezen or to issuing a get. I'm here to advise you to not sign such an agreement, as no court can compel you against your religious rights. If you allowed yourself to voluntarily sign, then you've made yourself a victim of your own negligence, and then the courts can coerce you to go to bezen or to give a get, as they will be doing so based on you violating your signed voluntary agreement. Please discuss the matter carefully with an attorney, and as always, do not violate court orders which might find you in contempt of court. I would like to conclude that the public should be made aware of Avi Kahan's flawed judicial practices. Anyone who participates in the public shaming campaign against Ari and his parents must ask forgiveness from them for the prohibited and unwarranted public shaming. It is my fervent hope that Ari and Chavi come to a true mediated agreement where both parties are satisfied, and in such a way, with God's help, Chavi can be granted a kosher get, and only with such actions can true peace be achieved. Please spread these videos to your friends and family so many more people can learn about authentic Jewish divorce law and not become victims of deceit from unscrupulous rabbinic judges. Until then, be prudent, be smart, and don't be gullible. For all my critics out there who don't want to accept my words as being true, I invite you to read letter number 7 in the description box below, containing 27 signatures of respectable rabbis confirming my statements about Avi Kahan as well as other bezens' malfeasance in matter of gittin. Thank you all for watching, and see you all in the next video.